we can start the session. Good evening, everyone. Again, this is the session 4, Media and Laws. We have, like all the speakers today, the 2 speakers here today as well, don't need any introduction, but I need to do the customary introduction nonetheless. We have with us 2 senior lawyers who have extensively worked on civil liberties, freedom of speech. We have Mr. Shyam Divan and Sanjay Hegde. Shyam, again, needs no introduction, senior advocate at the Supreme Court. Has been practicing constitutional law and, of course, matters pertaining to civil liberties for much of his professional career. He's also authored a book on environmental law and policy in India. He's a recipient of the 2021 International Privacy Champion Award from the Electronic Privacy Information Center. But other than that, of course, his proactive work in cases of free speech are all too well known. And so with Sanjay Hegde, again, a very leading voice from the bar on fighting for cases of civil liberties and freedom of speech. He's been a lead lawyer for the Ahmedabad-based NGO, the Center for Social Justice in the Supreme Court. He's played an important role in the Nirbhaya case, where he was appointed amicus by the Supreme Court. He's been a counsel for the CBI Director Alok Verma in his case against Twitter. He himself Twitter account has been blocked twice. Once for posting an image, the iconic image of resistance. It's still blocked. The iconic image of a person, in a sea of, Nazis salute, standing as an act of defiance. And the second tweet on the poem Usko Phansi Do by the Hindi poet Gaurav Pandey. So Sanjay knows too well, the implications of the hard hand of the way both laws and also the social media channels can sort of impinge upon freedom of speech. And his account, as Sanjay said, is still blocked. So to lay the context for this session, I mean, we've had 3 sessions before that. In almost each session, a large part of the discussion has been how press has been and is under great attack on account of laws, on account of arrests, on account of cases that are lodged against either journalists or the media organizations. And the sense amongst journalists is that we are operating under a very heavily coercive media legal framework. There are criminal laws starting from sedition, UAPA, Offensive Speech Act, Official Secrets Act, Blasphemy Act, and so on, which are used freely, almost recklessly, almost liberally and casually to file FIRs against journalists. The arrests are prompt, and the process itself becomes punishment. Of course, the sedition law has been put in abeyance, in response to a petition filed, amongst others, by Editors Guild of India, where Shyam was the lead lawyer. But the fact remains that the number of provisions available are far too many, therefore used far too liberally. And beyond the criminal laws, then there is another whole gamut of laws which are on the commercial side, whether they are laws which are meant to regulate media. There is still the existing Press Registration of Books Act, and the government is proposing a new Registration of Press and Periodicals Act, which has far more provisions allowing the regulatory authority to check or to create some kind of a hindrance for the press, for the newspapers and magazines. There is the Cable and Television Newspapers Act. There is the IT guidelines that were put in place last year. And then there is the new proposed digital media bill, which is already in work, some say, and the Minister of Information and Broadcasting has already made an announcement that it will be tabled soon. And the sense is that all of these laws have provisions that allow the regulating authority to take cognizance and take action in case of content they feel is obscene, against public order, against security of state, friendly relations to foreign states, essentially all the exceptions that are spelled out in 19.2. The unfortunate, and this is maybe a subject of discussion today, that while there is freedom of speech guaranteed by 19.1a, but the gamut of restrictions or exceptions allowed under 19.2 is far too wide. And the way those interpretations have been incorporated in this complex maze of laws and further how those laws, how the its interpretation, how those provisions are interpreted by various governments, law enforcement agencies, and the way journalists and media organizations are made to undergo a very rigorous process. And then, of course, there are laws under the PMLA, the IT, income tax, I mean, the way income tax can sometimes be used to raid or do surveys against organizations which have been critical of the government. Those are all, those are all adding to an already excessive system. And today itself, while he's not a journalist, Saket Gokhale, the TMC MLA or TMC spokesperson, has already been arrested for a tweet under some Representation of People's Act for promoting enmity between classes. Siddiq Kapan, who was been in jail for, his references come through the day in today's discussion, has already been in jail for more than 2 years. He was granted bail under UAPA, but then he's been again kept under custody because of PMLA charges. And I think just a couple of days ago, the state has framed charges under PMLA, which has become far more draconian act than probably many other provisions that are there. So the sense from the journalist community is that we are living in a very, very precarious legal environment. That environment has probably existed forever because most of these laws, I mean, UAPA was a newer law, but many of these laws have been in existence since independence in most cases. But the system has somehow become more oppressive lately. What are the solutions? I mean, much of the day today has been about spelling out the instances where journalists, media organizations have been at the end of a very draconian and a very heavy-handed state. But what are the solutions? There is one solution that, of course, we were able to manage, which is of putting sedition law in abeyance, but that is only one law. Last year, there was an FIR that was lodged against some of us, including me. Rajdeep was part of it, against reporting on and Nal Pandey, Shashi Tharoor, I mean, journalists and politicians all put together for reporting on something that happened on the 26th January tractor rally. Now, the list of provisions that were made part of the FIRs, and there were same 10 FIRs which were filed from 10 different places, is exhaustive. 153A, 153B, 295A, 298, 505, and so on and so forth. Some 10 different provisions within criminal law and Section 66 of the IT Act, which incidentally, I don't think so was operational even at that time. The problem is that the menu card for using these laws is too wide. So what are the options for media? What can press associations do? What can journalists do? That is something we would like to sort of hear the two panelists speak on. And of course, the genesis of many of these problems as well. Shyam, if you could start the discussion.
Yeah, sure. I will. That's quite an ask, but let me just broadly indicate some outlines in terms of how I understand, the laws which you mentioned, many of them which you mentioned, and the broad regulatory landscape. And I think there was a couple of very important points that you stated, and those were with regard to, the continuum. In the sense you said, you used the word precarious to describe the current state of affairs, but you also recognized that this is not something which is particularly new, both in terms of the law and in terms of the threats. So let me just use these first few minutes to broadly outline the way I look at the larger scheme and some of the main problems in this area, and then maybe we can talk about solutions as well. So the first thing is that as far as media law and media rights are concerned, entitlements, the space which you are entitled to, my personal view is that it's embedded in what you might describe as the common law of India. I might indicate that that's not an argument that has run very successfully on certain occasions. But the point is that even if you abolish or say take away your constitutional right, the first question is, do you have rights independent of your constitutional rights? And I think the answer to that under our general scheme, and particularly celebrating 75 years, etc., independence, and having worked the Constitution for all these decades, even without looking at the Constitution, every citizen has a right to free speech, and there is, apart from that, a right which is vested in the press and now more generally in the media to be free, to be independent, to articulate views, and therefore take away all laws, and you still have, in my view, the kernel of a right and the foundation of a right. Now that gets reinforced at the level of the constitutional provision. But the constitutional provision which reinforces the right also has certain exceptions. So it's much better to have a right, the way I see it, in the black letter law of the Constitution. And while we have no special right or special privilege insofar as the media is concerned, under our Constitution, 19(1)(a) of the Constitution has been interpreted to contain all the essential elements which are required for a free media and a free press. So that's a very, very important aspect of it. But it goes one step higher. So as you know, we have a judgment which is called Keshavananda Bharati, the fundamental rights case. And in that case, the Supreme Court, essentially to preserve the core values of our Constitution, recognized or declared that there are some core values in the constitutional document which cannot be amended out of the Constitution. You cannot remove those. And those in judgments, in subsequent judgments of the Supreme Court, have been articulated and explained. And freedom of the press is recognized as part of our basic structure. So it's an absolutely fundamental of the constitutional system that we have adopted, which means that the Constitution, at least according to the Supreme Court, in theory, places these rights and freedoms at a very, very high and elevated level. As we know, the Constitution itself recognizes exceptions. And therefore, Article 19(1)(a) itself has specific carve-outs later on in Article 19. So if you have issues such as, and these are the ones which were mentioned, aspects of contempt of court, security of the state, foreign relations, national security and integrity, defamation is one of those specifically mentioned in the Constitution. Now, this happened after a large amount of debate in the Constituent Assembly, and by and large, there hasn't been, in my view, too much tinkering or dilution in terms of how this is interpreted. So these categories haven't been constricted. If anything, they have been expanded through the process, through many of the laws which you, in fact, mentioned a little earlier. So we have the common law, we have reinforcement through constitutional provisions. Number three, we have judicial decisions which take this up to the level of the basic structure of the Constitution. Now, what's happening now? I recognize that this is part of the continuum, but I think what's happening now is this enormous digital transformation that is taking place, with all its disruptive impacts and elements, is having its effect naturally on the media space, and most visibly on the media space. So you have these new technologies which are coming up. You have this spread of the manner in which we communicate, the manner in which we do journalism, the manner in which the media operates and reports. And we're trying desperately. You did mention, again, Anant did mention new laws in the pipeline, and we'll have to await those, the final forms which they take. But I think society across the board is seeking to respond to this huge digital revolution which is taking place. So we have certain institutions and certain organizational structures which are adapting to the changing times. But this is no ordinary time in terms of the technological transformation that we're undergoing. That is like, that happens probably uh, in terms of centuries rather than in terms of decades. So I think we're in the midst of one of those huge industrial slash technological revolutions, and therefore are trying to find the correct fit in terms of laws and in terms of institutions, because new institutions will have to be built to combat. And in the meanwhile, of course, the present set of institutions and laws, we're trying to fit them into this, to adapt to this new landscape and to the new challenges which we're facing. The other point that I thought I should mention over here is that, look, there are hard laws or black letter laws, laws which are in the form of statutory provisions, whether they're rules. And then there is a very important element of soft laws. What I mean by the expression soft laws is that you may not have a specific statutory provision. However, all power exercised by the state is a public trust. And when you're exercising that power as a trustee at any and every level of government, you can't expect, and there isn't, a rule book by which you have to play. And that's why some of those statutes which you mentioned, which are general statutes, you mentioned, for example, the tax laws. Now, those are tax laws which have, we're not in any manner going to have a situation where, say, your general taxation law, I'm just giving you one example, say, the Income Tax Act, which has a power of survey, search and seizure, etc. It's not as if the search and seizure, the income tax law is likely to be abandoned or repealed anytime soon. Even if it is, it'll come back in some different form. But the point I'm making here is that when that is deployed, or when you have an agency of the state like the enforcement directorate, for example, deployed, or you have your income tax department deployed against media houses, for example, you have a situation, the way I look at it, where officers, bureaucrats, who are really your first line of defense, your line of defense in terms of the courts is absolutely final and much, much later. The first line of defense is that if you have a sensitization amongst the officers who are conducting the raid, that look, is this really for the purpose? Can this be done? Now, this might be a little bit in terms of wishful thinking, but we have to hope and expect that these general laws, at least, will not be used as tools and instruments of harassment. Is it something new? I think not. I think these general laws, whether they were, if you just examine sort of the earlier Supreme Court judgments which dealt with media versus the state conflicts and contestations, you find that there were tax laws which were being used. You would find that there are labor laws which were being used to and the end was to somehow try and stymie or control dissent or restrict dissent. So I think those battles are going to continue across the board. I think from what you mentioned, in terms of individual journalists facing huge and enormous problems, I think the time for organizations, perhaps like the Editors Guild, etc., is that you're going to, if you see this and you perceive this as some sort of a incursion which is going to occur and keep occurring, then you may have to organize yourselves. You may require to have defense teams across the country. You may have to have defense funds which are created. And those teams and funds, and you will find volunteers who will come forward to assist you in these regards, may have to now include, chartered accountants, because they're the ones who are going to advise you on elements of taxation, foreign exchange, whatever. You may have to have lawyers, you may have to have human rights activists, etc. So if the threat is severe, and if you feel that it is not going away anytime soon, then I think the system allows enough space to organize yourself, to create these teams, etc., to combat and contest actions which are taking place right down to the, to the lowest level of individual journalists who might not otherwise be able to engage, or get the best help which they require when they're suddenly arrested and stuff like that. So I think the point I was making was in terms of these implicit norms in an open society. I think those are some things which we can keep in mind. But I mean, I think that's quite enough for at least these opening remarks. So thank you very much.
Yeah, thank you. Sanjay, would you like to? You'll have to
Yeah.
unmute yourself. Yeah.
Well, Shyam has given you an extensive, broad view of the problem of the landscape, as it were. In fact, what it does appear to me is best encapsulated in what the late lamented Idi Amin Dada of Uganda once said. He said, "Freedom of speech, I can promise you. Freedom after speech is a different thing altogether." And it is exactly it's one of those situations where you have a frog put in water that is heating up continually, and the frog has not yet jumped out. If you directly put a frog in boiling water, it will jump out. But if the heat is steadily applied and steadily increased, that's when the frog may reach its end. And over the past few years, the temperature has risen. The question is, what can we do to reduce the temperature and essentially to produce a more resilient frog? It does occur to me that a lot of the weakness of the media is also due to members of the media themselves. Well, we were discussing the institutional failures by individuals in the judicial system. It was a couple of journalists, and they were Hindi journalists who said, "अरे, मुझे भी याद है कि हम कब गिरे थे। हम तो किसी ने ये नहीं कहा था जब चौधरी ने वो स्टोरी चलाई थी." So it is essentially when media men, media organizations align themselves with the interests of the executive, when independence is traded for access and favor, that the media allows itself to be a commodity that can be traded, that can be disciplined, and can either be subverted, bought over, or manipulated in a myriad number of ways. Now the question is, of course, whether it is the legal profession, whether it is media, the vast majority consists of hardworking people who see their profession as a job which has to be done well, and done to the utmost. How is it that the institutional integrity has to be built up so that the fish stops rotting from the top? And well, there have been various people who have come out with various solutions. But I am not here to just give advice on a mega scale or deal in platitudes. What also has to be done is that at every stage there has to be a fight back. At every stage there have to be people who simply stand up to continue the system. Why is it today that the policeman who decides that I'm going to throw a journalist into jail and throw away the key, as has happened in Siddiq Kapur, why is it that the policeman is so dominant? By the policeman, I mean the executive. It is dominant because there is no pushback. The pushback from the judiciary has not happened. It has been processing the case. Each stage of the case is treated as a separate stage, and the kind of instant intervention that the arrest of an Arnab Goswami saw has never happened in the Siddiq Kapur case. Why is that? Equally, the banding together of even that section of the media which protested the Goswami arrest has not been equally eloquent or equally vociferous in the Kapur case. It was the Kerala Union of Working Journalists who instantly took the Kapur case to the Supreme Court. The Supreme Court at that point of time did not really intervene. Then COVID came in and the matter went into various cold storages till one part of it got resolved a few months ago. Nevertheless, the other part, by then, the prosecution had launched two separate strings to that bow, so that even if one string, the UAPA, broke, the other string was still alive to continue the process. Why is it that both our institutions, the media as well as the judiciary, have lost their essential bite? And what is our essential bite? The essential bite is the ability to ask and to transmit probing questions. Why is Mr. Kapur still in jail? How can we say that there is a case against him to answer under PMLA? Does covering the Hathras rape case make somebody a terrorist? Is subject to action under UAPA. Now, if at the end of the process ends with Mr. Kapur getting bail, but the trials continuing, and at some stage, ultimately under some other government that's somewhere in the distant future being dropped, then any future government that is minded to act the way that this set of governments is currently acting can take exactly the same question. It is when the judiciary asks the question, who took the decision to arrest him? Who took the decision to invoke UAPA? Who was it who took that decision to invoke the PMLA? Let's have an officer. Let's have a name attached to that officer. And let us at least take such action so that the law is not misused again. But the judiciary also does not do it. The symbiotic relationship between public clamor, the way that institutions like the media influence the public discourse, also influence what happens in the judicial process. Now, Shyam spoke about creating funds, creating allies, especially in human rights defenders. And it's all very right to say that, we have a Supreme Court, it tries to come to the aid of everyone as and when. But that is not what is required all the time. You do not bring every problem to the Supreme Court. What you really need is networks which extend to every district and to every police thana. There should be identified defenders who could work extensively, even on an informal basis, with professionally reputed bodies like the Editors Guild, some kind of mild form of endorsement or accreditation, who can go to the police thana, interview the person in custody, talk to the policeman, see to it that the early recordings of witness statements or whatever do not go by default. The very hard nuts and bolts operation upon which cases then finally live or die in court, that should be taken care at the first stage. And again, there is often a symbiotic relationship between lawyers who fight and the media who dares to portray exactly what is wrong. These linkages would really have to be worked at, and on a more organized basis. Shyam and I and many others are willing to give off our time or even some of our resources where there's a fight on in courts that we practice in. But the first line of attack is upon the stringer in Jumri Talaiya. And if something happens to that stringer, who is it who speaks for him? So freedom, as they say, is indivisible. If you do not fight it at the ground level, if you do not have an organizational system, even if on an informal basis, then the executive, which is much more organized, which works on government funds, will inevitably win. And there has to be a blowback for every act of oppression. It can't be that specifically when journalists do not stand up for journalists, when there is not even a bit of at least trade union loyalty, that is where you render yourselves all vulnerable. I think these are the two broad trends that I've seen over the past few years. I would pause here and let Shyam and everybody answer questions which are more specific.
So Sanjay and Shyam, you both talked about the problem at ground zero in a small town and for us as journalists, we also recognize that when there are cases filed against some of us, when we are in big state capitals, we are represented by our own institutions, we have greater access. And this is a point that Rajdeep made in his last session pertaining to his FIR. You have access to lawyers like you, other lawyers who are willing to help. It's far easier to sort of, manage the onslaught. The problem is for a journalist in a small town who may or may not have an institutional backup. Even if there may be an institutional backup, the institution might itself be very small. In many cases, a lot of journalists are now independently working, as the media landscape itself has changed, and media itself, very admittedly, has become far more conservative in questioning the government. Many journalists have either started their own YouTube channels or their own whatever blogs they might have, or if they're even running a small publication of their own. What is the institutional protection possible to them? And one of the things that you both touched upon was the sensitization of the law enforcement agencies. Now, given the fact that all the law enforcement agencies answer to the political masters, and where is the hope for a real sensitization to happen? Where is the hope that the ones who will first interpret the law, which is the police officer when a complaint is filed in a local thana, the SHO of that local thana, will himself or herself be a first level of some you can say objective vetting whether this complaint has a merit or not. And we have seen multiple times over the last few years, complaints of a certain kind are converted into FIR far more readily. Complaints of a certain other kind remain as complaints, and this is a trend which is only becoming worse. Is sensitization really a possible approach, and what form of sensitization? What is the way to create the sensitization?
I think in terms of sensitization, I'll just come to that in a moment. But I think something which you can do and which you can contemplate. It's something really within the capacity, say, of Editors Guild of India. If you haven't done it already, I think you can have a I'll call it a toolkit, but you may call it a cookbook or whatever more appealing expression you can think up, which is a method or what is to be done should A, B, and C happen to you as a journalist. What are your right? I mean, explain that and have that up and ready and accessible in every language which is available. Who can you contact? What are your rights? What are I mean, essentially you need, it's like an emergency response situation. If you feel that journalists across the country, and that's your experience, are finding it, a pressure cooker atmosphere where there is this constant threat or apprehension that X or Y or Z may happen. What am I to do? Then you need to have those kind of first responders, responses, next level, third level, fourth level, and that requires creating some sort of a document which can be updated, where people can share their experiences. It can be improved over time, and also obviously having coordinates of persons whom you can connect to locally across the country, so that can be some kind of a helpline type of a situation where how this can be dealt with. In addition to the point which I made about there used to be an environment defense fund in certain jurisdictions, and I don't see why there can't be a journalist defense fund over here. Look, sensitization there's a huge, it's a very slow and gradual curve. I mean, that may be a task which is way beyond, say, press organizations, etc., because sensitization is required for each one of us as well as we sort of grow and as society changes. And I can think of, as far as the police thana is concerned, several other laws where a degree of sensitization is necessary. So I think that kind of ground, that sort of solution at the ground level, I am not really in a position to offer. But you did mention in your opening remarks that at times it may be possible to have certain guidelines laid out or reinforced by the Supreme Court, and at least in your first line of defense, not at the police thana level, but at least at the magistrate level and at the level when arrests, etc., are apprehended, if you have certain stronger protections, that is something which can be done through a court. The next point I want to just build on is something on what Sanjay mentioned. Look, I mean, the nature of the system and the nature of society is that you have to have a certain dependence on courts. And, both Sanjay and I are part of that system, but I don't think we should necessarily be, have some great rosy impression about everything going right in our courts, because our courts also are subject to, the usual frailties, weaknesses, and apart from the enormous burden of work. So while we have strong principles which are laid down, in individual cases, that challenge is going to remain. But there is still a space for, I feel, a sort of judicial oversight. Now, the judicial oversight I'm speaking of is that you have certain situations where, for example, in the context, say, of film censorship, you had tribunals. Now, I'm not a great votary of tribunals, but that seems to be, the flavor which has appealed to various administrations at the central government and even at the state level for several decades in India. And I don't see an immediate threat to the tribunalization of our system weakening. I don't see that trend weakening. But if you have a tribunal, it's dangerous. Dangerous in the sense if you have the wrong personnel on the tribunal, it can be a disaster. But I suppose optimism is part of working in an open society and in a democracy. So we have to hope that we will get good personnel. And my sense is that for recourse in many of these areas, which I'm sure will come up in the discussion as well, particularly in the context of the new laws which are likely to come, with regard to the digital media, what's right, what's wrong, what is to be taken down, you may require some kind of a tribunalization level, a tribunal. And if there is a tribunal with competent officers, with competent personnel which are trained, etc., we have to hope that at least they, in the context of media, will be a filter and will be a disciplinary force in terms of actions which are wrongful, and then you don't get stuck forever, perhaps, in the in the general court system. So that's something which has to be worked on. But I think I see an element of a possibility. It's certainly better than not having anything at all, considering that you're going to have a huge amount of discretion which is going to be vested in certain executive authorities, which is already there at some levels under the IT Act and the rules, and which is likely to build on. So that's the other point I thought I just made.
Anant,
Sanjay, yeah.
You used a wrong word, sensitization, with regard to thanas. I think the word should be desensitization. Essentially, what is the Thanedar's outlook in life? He wants peace within his local precinct. And within the area in his jurisdiction, there should not be any tamasha. That's his brief. Now, please take it from that whenever there is a situation, the situation can either be of a politician who is called up, or it can be the case of a mob which has descended and said, so and such fellow has spoken out of turn, and our religious feelings or our particular heroes, there has been some lack of deification of them, and you have to take action. Now, what is it that the Thanedar is prompted to do? He says, look, this is the source of the problem. All that I have to do is to lock the problem up, and then it no longer remains my problem. It becomes a problem for the courts and for the person locked up, because I have shown that I have taken action. Then whether the courts release him or not, that's the court's business. So the essential logic that journalists have to be aware of is that in dealing with the Thanedar, what he wants is for peace within his precinct. So how do you turn that around? If he takes wrong action, you have to ensure that wrong action is continually questioned, that the cost of giving in to the politician or the mob is not as great as the cost of the questioning that he will face later, both in the public sphere as well as in the courts thereafter. And I do agree with Shyam that it is high time that manuals and checklists are put about as to what is to be done in a situation like that in each district who are the professional bodies that can be resorted to, the professional bodies of journalists, the professional bodies of lawyers. Who is it who will be there to handhold through the police thana proceedings? Who will be there to handhold during the initial court proceedings? And who will be there to escalate the matter if required? And very often, just like you have a golden hour in medical interventions, what happens in the first day or two after the arrest, the recording of statements, that sort of sets the tone for what will ultimately happen in the case. The one thing that gives me hope, quite frankly, is that now we have an India where a lot of younger people have turned to the law. The smart kids who used to get into engineering have almost all come into various law schools. There's a whole host of talent out there, and talent from reasonably well-to-do families. They are hungry for cases. It is actually in a sense, a startup opportunity for someone. If they could be organized, at least for this cause of freedom of speech, which is a universal value. I do remember telling a friend of mine who was to be sworn in as a judge, take care of freedom of speech, everything else will fall in place.
No, that's a very pertinent point, Sanjay. I think we've seen this about the young lawyers joining the profession and their hunger, like young journalists, and this is something discussed in the previous panel itself, that the number of young journalists who enter profession with a great sense of idealism, it's something to recognize. And similarly, I guess in the judiciary or in the legal front, the number of young lawyers who are entering the bar and have a high sense of idealism is something that is maybe a ray of hope. We've seen with our own examples the amount of support, while of course the senior members of the bar give, but often the younger members of the legal fraternity are forthcoming. The way they're forthcoming to sort of offer help, to offer support, is something which can definitely be channelized, and it's something that we have to sort of maybe institutionally or as press associations maybe come together and create that network of cushion for journalists across the country. But the other problem, just saying, Sanjay, the one on sensitization on questioning the police officer, making the cost of questioning so high that he or she would think twice before registering a complaint on a very facile ground. There is a bit of a catch-22 situation there, because once a journalist is booked under the law and he's put in jail, any other questioning from at least the local media is sort of in a way put in lid on. And this is a practicality. Whatever the answer, I don't know, but practicality is that it's by examples. You file case on small facile grounds. Yes, the chilling effect. And many times you've seen, not just at local level, but at the national level, sometimes the cases that are filed against some prominent journalists on such a facile ground. It is not or the raids that are done, the ED raids are done, tax raids are done on very, very, innocuous grounds. The whole idea is chilling effect. So therefore, there is a bit of a catch-22 at play here, at least from the media then, in terms of questioning the police officer. When it comes to judiciary, and since this was, again touched upon by both of you, that judiciary is an institution which needs to be questioned as well. It is an arm of state, and the amount of power, at least in this case, they wield in terms of the way they interpret laws, the speed with which cases are taken up, and sometimes the arbitrariness with which the cases are taken up needs to be critiqued. Sadiq Kapan's case as a prominent example. But there again, the catch-22 problem is because of the prevailing contempt laws, which are very, very vague which are almost, which hand like a sword. I mean, every time we have to do a story on judiciary, it has to go through a solid legal check, and you- the lawyers are they're okay to for us taking us fight against the politicians, against the businessmen or whatever. But judiciary, the moment it comes to judiciary, everybody's sort of alarm guards go high up. And I guess the problem that we face is there is no clarity on what is contempt of court, whether we could upset an ego of a particular judge, whether another brother judge gets upset for the ego being hurt of another bench. There is sort of vagueness out there. Is there something that can be done to address a certain sense of clarity and also make it far more liberal to critique judiciary, like any other institution is to be critiqued?
Okay, I'll just tell you something which may be news to some of your some of the viewers and those listening in. And this is really about the embarrassment of Indian contempt jurisprudence. So you have a very eminent lawyer in Fiji, and his name is Richard Naidu. He's extremely well known, and a commercial lawyer, but does some human rights and other types of work as well. Fiji court, in its judgment earlier this year, instead of using the word injunction, used the word injection at 2 places. And so he just captured the from the judgment. He took a photograph and he made a Facebook post of it, and with a comment which was something to the effect that, look, in this time of COVID and whatnot, it shouldn't be entirely surprising that the judge is thinking of injections instead of injunctions. That's it. Now, several months later, the Attorney General for Fiji lodged a complaint that this amounted to contempt of court because it scandalized the judiciary in Fiji. And so, the international, many lawyers across the world are just astonished that this is something which could happen, and the Attorney General is asking for this person to be punished. Because the problem in Fiji also is that if you are punished for contempt or you're held guilty of contempt, then there's a possibility that there is a revocation of your license to practice. Because unlike India, where you have a bar council which issues the license to practice, in Fiji, it's much more centralized in the judiciary, etc. Now, the occasion arose before judgment was rendered in Fiji, whether we from here in India could support the effort and explain that, look, this is so frivolous and trivial that this gentleman, who's a lawyer, not a journalist, but had, made a remark on Facebook, ought not to be convicted. And frankly, when you look at the Indian law, it's such a dismal situation. Our jurisprudence is so poor on this count that we were really not able to help our Fijian colleague by lending him support of Indian jurisprudence, which in many other areas would have been highly principled and highly advanced, and would have been a sort of immense support to a human rights kind of case in most other fields. So the point I wish to make is that our contempt law is being extremely poorly used. I think unless there's a shake-up at the Supreme Court level in terms of the jurisprudence which is coming out, including the most recent jurisprudence which is coming out on the law of contempt, it's essentially, to me at least, pick and choose. You can almost tell from the course title of the case as to whether this is going to result in a conviction or not. And for all these reasons, I think this is a problem in not just being faced by journalists, but across the board. So my final line is that I think as journalists, so long as you're doing your work with, what Sanjay had also mentioned, with the discipline, with the rigor, with the support and the backing, you have to just go ahead and do it. And you, of course, must critique judgments of the Supreme Court and judgments of other courts when they are wrong. The, the line which cannot or ought not to be crossed is you cannot attribute motives to a particular judge that he or she did it for this reason or that reason. Otherwise, a well reported, a good report, journalistic, a good editorial, critiquing something is, I think, entirely permissible. And I would encourage people to do it because that's the only way in which the system improves. Of course, what lawyers argue in court, lawyers are constrained by the brief which they are arguing, and they're often, they're not often, they almost invariably are looking after the welfare and the best interest of the client whom they represent. So if they're getting something, they will be they will be happy to compromise a particular position. But I think insofar as journalists writing editorials and otherwise are concerned in terms of critiquing some analysis, I think it's necessary, far from being just apart from being welcome. It's absolutely necessary. But that line is, you cannot attribute motives because judges are very sensitive to that aspect. And there's also a compelling reason for that, because judges, don't forget, speak by and large only through their judgments. So there is there's a code of restraint on the part of the judiciary, and we must be respectful of that. And realizing that, I think any type of healthy criticism, including on the subject of contempt, is most welcome, desirable, and I would encourage it so long as it is well supported and well reasoned.
Sanjay,
On
anything on
this aspect, there's also very little chance that the legislature is going to do anything about it. So the only one who's going to really pull back on contempt in the near term, in my view, is larger panels of the Supreme Court realizing that we should change the law. But that's a difficult task.
Well, Shyam has more or less given you the entire legal position. So just let me illustrate what can and cannot be done by two stories. One is the background to the Supreme Court decision in re Sumant Mulgaonkar. Mr. Sumant Mulgaonkar and other editors had criticized the judiciary's conduct during the emergency. And it first came up, I believe, when Chief Justice Bahl was still on the Supreme Court. And it was he who initiated the contempt proceedings. This was after the emergency. And the brother judges after the emergency then got an opportunity to write great dissents as to what journalists could and could not do. Justice Bahl was left isolated on the bench. So it is not as if all members of the judiciary are equally solicitous that our personal honor is involved. As Shyam rightly said, that as long as you do not attribute motives, you criticize the reasoning behind a judgment, I think you should be fine. As the saying goes, small minds discuss people, average minds discuss events, great minds discuss ideas. So take it that your readers have great minds. Discuss the idea behind the judgment. That's one. The other thing is that there are ways also of criticizing. And one of the best stories, Mr. Rohington Nariman, later Justice Nariman, spoke of the British press of a particular newspaper which was reporting that the actress Lily Langtry had something to do with the Prince of Wales, who later became King Edward VII. And then the palace took to Cambridge. They had to recant. And they next day they came out with there is nothing between Lily Langtry and the Prince of Wales. The third day they added, not even a sheet. So there are ways of getting your message across, and it's not as if the courts can at all stages just wield the sword of contempt like a broadsword against everyone. You do your due diligence. You do have your legal teams on your boards. So I do not think contempt is as bad a problem, and more particularly so when the judges do not have the powers to launch the ED or any such other agency against you. The worst thing that happens in the contempt is 6 months imprisonment, and that is rarely given. Often ends up with an apology.
I'm going to dial back into history. This is Press Freedom at 75. We were talking about 19.2, the exceptions to 19.1. And the First Amendment of the US Constitution guarantees absolute free speech. Whereas the First Amendment to the Indian Constitution, under the time of Nehru, inserted restrictions to 19.2, public order, friendly relations with foreign states on reasonable, and the restrictions have to be reasonable. Do you think that the exceptions, the 19.2 itself, the whole clause itself, was in any way an original sin of Indian Constitution, whose effects we are increasingly feeling, especially in the last few years?
Can I take it? Or
Please. Yeah.
No, see, you must remember that the amendment was passed by the same Constituent Assembly. This was before the 1952 elections.
Yeah.
And so, in a sense, it was the Assembly which, having written the Constitution, said, no, maybe we got it a bit overbroad there, and they dialed it down. It was also at a time when there was, when the horrors of partition and the wounds were still raw, and there was a lot of anti-Pakistan propaganda and everything going on at that stage. Then there is, I think that comparing with the US, we also need to compare our two societies. The US is a much more individualistic society. And it's some of its states have even the motto of live free or die. Whereas we are a more, what shall we say, not exactly a tribal, but a very, the family is the basic unit of society. And an individual fits into the family and the larger social structures around. And so we are much more used to tempering our speech subject to etc., etc., etc. We have chosen that as our model, the model of many to define our individual freedoms. I do think we have gone overboard in its interpretation, where often the exception has eaten up the rule. All that the 19.2 says is that, if there are any laws made with regard to freedom of speech, with regard to friendly relations, etc., etc., you cannot fault them and say that they come in they are not consistent with the right of freedom of speech. But what our courts seem to have done is that you can freely speak about everything, but you cannot speak about X, Y, and Z, all that is stated in 19.2. And that is the approach which has led to the basic right being eaten up. Maybe there, yes, a certain amount of reconsideration is called for. I'll leave the floor to Shyam.
No, I just add that, look, almost everything in our constitution, there's nothing really which is absolute in our constitution at all. We've had over 100 amendments, as you know, to the constitution. So the constitution in India sort of, both from a judicial interpretation point of view and even in terms of evolution through changes by changing the letter of the law through a constitutional amendment, is perceived as something which is not static. It's continuously evolving, it's dynamic, etc. So in itself, my own personal sense is that with that these kind of exceptions which are engrafted in the constitution might have come through a judicial route anyway, or they might have come through in the form of piecemeal subsequent legislations as well. So I accept that a large number of the baggage which you have to carry in terms of restrictions today on free speech, take something like say defamation, for example, okay, including the criminal defamation angle. It is something which is there, which is protected. But if you ask me, even if you drop that defamation protection from the from from Article 19, you might still have, through a judicial process, because equally the courts are conscious that, look, reputations have to be defended and protected, and therefore there has to be some system by which people cannot abuse their right of free speech so as to defame somebody. So it would have worked into the system anyways, though perhaps not at a constitutional level, is the point which I'm making. And look, after 75 years, we have to live with it. We have to push it. Let me ask you, as a journalist, which is the question that, look, if you are doing your journalism in a thorough, proper, well-researched manner, do these exceptions really bite as far as you're concerned? I do see that, yes, they could have a chilling impact in many situations where someone wants to, kill a story, particularly, I mean, to build on the defamation situation, you may be slammed by some sort of an action. That kind of an action could perhaps be initiated even if there were no defamation exception in the at the constitutional level.
No, actually, the answer to that is, absolutely yes. That even on very innocuous and objective instances of reporting, and this is, let's say, take specific examples of offensive speech, hate speech laws, 153A, 295A. More often in recent years than earlier, perhaps, a report on any kind of communal violence, any race-driven violence, any other ethnic clash, just a mere reporting of it itself can invite a complaint, an FIR, incarceration, and then years of a process which is very cumbersome. So we have seen multiple times in multiple instances, and this is just a criminal law. What we have seen is a pattern where now the new RPP bill, which has been floated, as against the earlier PRB Act, which was simply a catalogue of newspapers and magazines being printed in India, simply from the purpose of indexing and cataloging it, and did not assign any liabilities or did not sort of have provisions under which any government officer, whether it was the registrar of newspaper or any other such authority, could have stopped a publication from publishing. Today, the bill that has been envisaged allows not just registrar of news, the registrar himself, but an authority that can be. This is in the bill. I mean, so it is not a law yet, but in the bill, at least the registrar can appoint an authority, which we don't know. It could be maybe a IAS officer, it could be a state office, service officer, we don't know, to take cognizance and take appropriate actions. So the problem is that words are appropriate, reasonable. All these words, which can be interpreted by whichever way any government officer might want to interpret, has become a real liability. And now, with the new digital media law that is being proposed, or the bill that is being proposed, similar problem. The IT guidelines that were introduced last year was another backdoor entry towards regulating digital media. And this is something that we've discussed in recent past as well, that the government has, the regulatory mechanism of the government is sort of zeroing in. There is the PRB Act, which is being replaced by RPP. There is the Cable and Television Regulation Act. There are the IT guidelines, and now digital media bill is being proposed. In all of them, they are taking their exceptions. Those exceptions are being used to give power to somebody whose interest is with the executive. who's not a judicial officer, who's a servant of who's a government servant, to decide whether prima facie something is libelous, offensive, indecent, all the exceptions. So that's the harsh reality that we are facing.
No, so I recognize that that is a troublesome architecture, particularly if it gets sort of baked into the law, etc., at some early point of time. I have made the point regarding some oversight tribunal, which is entirely judicial. I mean, that's the minimum test which you require. But yes, I think these contestations are going to occur, and I think at least the way I look at it, I mean, not as cynically as one perhaps should, but just a little more objectively, I think part of this is also because of the digital transformation which we're going through. Part of it. We're finding that there is this speech which gets amplified so quickly and gets around. Is there a need for some governmental regulation of, say, something which goes under, that badge of fake news? That itself is, of course, is debatable as to what amounts to misinformation, disinformation, and fake news. But I think most of us would recognize that there is a need to somehow scotch these type of false stories which get magnified through, the bots and whatever works, the trolls which work the system in an automated manner. So there is a need to somehow address that issue. I don't think self-regulation by itself is going to answer that question. So then, if you're going to have some degree of governmental intervention and oversight, what's the best manner of doing that?
Sanjay, anything?
Yeah, I mean, I just picking on a point that Shyam made about the amplification by digital media, especially social media. I think it's also time for a line to be drawn by either the judiciary or the legislature on where exactly are criminal proceedings to be launched, especially with regard to social media. Now, you tweet from Delhi. The impact might be felt in Assam. Now, do the Assam police or do police all over the country then take action? Or will it be sorted out so that only one set of people take action for that particular instance? Right now, this has also become a tremendous tool of harassment, because somebody may have put out a social media post with regard to his perception sitting in a particular place. And if there is an organized effort on the other side to not only bring down that particular bit of speech, but also the speaker himself or herself, the technique is to, let's say, sometimes file complaints all over one state, so that no, like you just mentioned, the Saket Gokhale case. No sooner has one police station been ordered to release you on bail that another police station takes over. So there is a kind of relay race from police station to police station, magistrate to magistrate, till you either approach the High Court or the Supreme Court and then say, please consolidate all proceedings. So this is one area of the law that really needs working on. I think that would go a long way.
Anant, on the other point which you mentioned, I just was wondering, in terms of reporting, communal incidents, etc. Are there any guidelines in place, or is it completely ad hoc? Has something been structured that, look, reporting of all these particular elements is absolutely kosher, permissible? In fact, it's a duty on the journalist to report these elements. It is permissible to take photographs, etc., etc., etc. And then there are those guidelines which are possibly there in terms of not identifying, certain who the community or whatever. But but is that fairly robust in terms of being available to ground reporters, where people can say that, look, if I follow this template, there's no danger for me? or is there a problem with regard to that as well? Because otherwise, this knee-jerk, the local government, which might, whoever it is, might just find that, look, why are these pesky journalists elevating this, etc., and may, in the immediacy, lodge a complaint or two. What is the thing? Because otherwise, there's probably a space to create guidelines and detailed documentation apart from the government handout as to what can be done, and support that kind of thing with examples and instances. And probably you might be able to get, some retired justices of the Supreme Court of India who will lend their opinion and say that, look, these kind of reports are absolutely fine as an example in our opinion, etc. And that can be the kind of guideline on what is good reporting for other journalists across the country moving forward.
So, to the best of my knowledge, I mean, there is a code of conduct that Editors Guild has, but it can definitely be more comprehensive, and I don't think so. It's something that is well circulated, well, it's not permeating something through the ranks of journalistic organizations. But having said that, that code itself is also requires maybe an updation. There is the Press Council of India Code of Conduct. However, that has a problem. And again, there's a question somewhere somebody posted regarding can Press Council of India punish rogue officers? I mean, it was in a different context, but it's maybe a nice point to bring in this body, which is supposed to be the nearest to some sort of a self-regulatory body with some parliamentary sanction. And it is supposed to fight for freedom of speech. It is supposed to also regulate media in terms of wrongful reporting, any wrong, let's say, contravening any established, accepted norms and guidelines. Now, the problem is that with the guidelines the Press Council has spelled out, some feel that they are also written from a point of view of government perspective on what is those professional norms. And the reason I'm emphasizing the word government is because many times the onus is put on the reporter, again, using words that you should not write something which will incite communal violence. Now, what does that mean? Again, that can be interpreted in multiple ways. That can always say that, okay, fine, just reporting itself is also inciting violence. And this is just an example. There could be many other places where it almost feels that the effort is to be more conservative from the reporter's end. So there is to answer your question, that there is an area of work required in establishing guidelines. In fact, there's a question here which was there, and maybe we can move to some audience questions. That do you agree that there is a need for a legal and institutional reform like Chhattisgarh Journalist Protection Act? To be honest, I'm not too aware of it. If either of you are aware, and also thinking of giving punitive powers to Press Council of India to punish rogue officers. That's a question from one of the audience members here. Do you have a response?
I'll yield to Sanjay. I'm not aware of the Chhattisgarh specific statute either.
Or if you want to say about Press Council of India itself, what could be the role of Press Council of India in this framework?
Well, the Press Council having punitive powers by itself would be, in my view, not constitutionally right. At best, the Press Council can be given powers to specifically file complaints in a court of law and to see those things to a logical end. Somewhat like a prosecuting agency in cases of gross misuse of on the part of the police. That to that extent, I might agree. But the Press Council itself becoming a punitive agency, that won't stand muster. What do you think, Shyam?
I think the task before us in terms of the immediate agenda is if on several global indexes, and we're not saying that India should be above this country in terms of freedom of whatever, speech and expression and freedom of the press index, or below that country, and this is wrong or that is wrong. But the general drift appears to be on fairly objective matrix and fairly thorough reading, say, in terms of a rule of law index, which came out a few months ago, that we're doing badly. So I think every person who is involved in that sphere of work, including the press council, should be endeavoring to try and ensure that we move up on this ladder of nations and score much higher than we generally do, or at least what the global perception is. And probably even come up with our own index if we are not satisfied with other indexes which are being worked. So I think that's the thing. And in that, to have a penal power, I'm not very sure about how the press council is likely to sort of work in that area. I mean, I haven't really thought that through.
Okay, Seema has been just sending some messages that there are guidelines at a newspaper level, which I think that's true, that maybe institutions might have their own guidelines, but definitely there is you know a reason for bringing out a more thorough manual, if we may say so. There's a question by Garima that, do you think the use of UAPA can be concerned with the doctrine of colorable legislation, as it indirectly but actually hinders with and is contradictory to the parts of constitution that are seen as basic structure of constitution and fundamental rights, as in Article 19 and 32?
My answer to that would be that, look, let's just wait and see as to what is going to happen to this sedition business. Because there was some, there was a pushback by Chief Justice Ramanna, and at that point of time, there was some hint, or at least some kind of I suppose a hint is about as much as I can say from the law officers, that maybe given the fact that we are celebrating a milestone year after independence, this might be an occasion to get rid of some kind of colonial baggage, sedition provision included. So I think let's just see how far the government goes on this element of sedition. I think as far as UAPA is concerned, given our geopolitics, etc., and it's not going to disappear. It's not going to go away. Assuming it's withdrawn, it'll come back in some other form. I don't think the judiciary is going to, even if convinced that there are grievous excesses, is going to strike down the law in itself. It might at best say that, look, individual excesses have to be remedied and we need a system to address that. But on a call like this, which at least at a general level, not from a journalistic point of view, but at a much broader level, involves aspects of state security, I don't think you're going to have a judicial pushback at all. So at the most, so this whole business about striking it down as colorable doesn't appear to me as realistic in the present state.
You must remember that the judiciary upheld TADA, and then it was the legislature which finally said that, look, it's been abused so much that it's best withdrawn. And then you had POTA, and you've had the UAPA, which was the 1960s law, which has then been refurbished, and now with some judicial interpretations, including the Watali judgment, has become the current tool of oppression. These changes do not necessarily come from the courts, as Shyam has told you, because the courts are very rarely strike down things as being unconstitutional. And there are several provisions of a very long constitution which seem to buttress some of the thinking behind even harsh laws. So yes, change, if any, has to come from Parliament and from the people as such. Unless you push your parliamentarians, nothing is really going to happen. But right now, we do not seem to be in an era where society believes that parliamentarians are their servants. We seem to elect people and then exalt them into demigods for the next 5 years, 10 years, or whatever it is.
There is a general question again on constitution, that what may be the ways to generate faith in constitution and constitutional values in society. Otherwise, the constitution might just be rejected in entirety.
I don't think it'll be sort of rejected in entirety, but I think it's a constant endeavor to, for all of us who believe that in the success of the document and in sort of moving towards a more perfect or better society, that you have to continually remind people that these are the basic values and they're worth fighting for. And since you brought this up in terms of, this particularly precarious time for journalists as a community, I think apart from doing the individual jobs which each one is doing admirably, you have to at some point be in some kind of advocacy and campaign mode. And an advocacy and campaign mode essentially means building larger networks across the country, being in touch with each other, exchanging, the problems, etc., and running stories on whatever media outlets which you have on these core values of constitutionalism, which I think I agree that we have to be reminded of. Each one of us has to be reminded of. Otherwise, lest we sort of, forget that freedom of the press is something really, really, worth fighting for and educating people about. There's also a citizenship program which has to come through at every level in terms of schools, in terms of colleges. So not just your general civic class, but just being better and fuller and more complete citizens. And I think that comes, I suppose, through reading media reports, however they are consumed. And I guess that's a immediate challenge for you guys, because I find that amongst the, many generations, all of them younger than me, the newspaper and traditional media outlets like magazines, etc., are not being consumed as they would in a package. They're sort of being consumed as, stories or whatever, individual stories on Instagram or whatever. So I think that poses its own set of challenges.
Okay, we are coming to a close to the session. Any closing thoughts from each of you to round this up?
I was just picking on that thought on constitutionalism.
Yeah.
And I keep quoting that particular line from Justice Learned Hand in a very famous speech called The Spirit of Liberty. And at the height of the World War, before the tide had begun to turn against Hitler in 1944, he was swearing in people into American citizenship. And he gave a short speech which people should continually read. And I too hope somebody takes upon himself the job of translating it into Indian languages and writing something in that context. And there he says, liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it. No constitution, no law, no court can even do much to help it. So each of us carries that burden of ensuring that not only do we safeguard our liberty, but in safeguarding our liberty, we safeguard the liberties of our fellow citizens, because ultimately, eternal vigilance is the price of liberty. And no constitution can survive a disinterested citizenry.
Well, I think my last thought is just simply this, that so long as we excel or endeavor to excel in our respective fields, whatever form of journalism which we're adopting, I think good quality journalism and really good work is universally appreciated, required, and consumed. And so at the end of the day, so long as journalists continue to produce high quality stuff, there will be a need and there will be the recognition.
Right. I mean, picking up on what both your Sanjay, Shyam, your thought and what Sanjay quoted, it's very clear that the onus, of course, the first onus lies on us. In terms of what we do in our profession, how we fight our battles, and the solidarity with which we fight our battles. So there is a clear recognition that that is where the first line of defense or fight has to come from, and of course, along with that, the network of support that we can get from the legal fraternity is something that is becoming ever more important. I mean, personally speaking, I have more lawyer friends than any other profession. So I mean, and probably by a great margin. I'm sure it's true for many journalists that you end up just making far more lawyer friends. Especially as I guess more in the recent times. Maybe it was there always. I mean, these laws again. Let's not discount the fact these laws have been there always. They've always been used. They've always been used in various parts, by various governments in their own to their own benefit and advantage. What we are seeing is, of course, a far more, you can say, blatant use of those laws, and which also, I guess, adversity creates the greatest, innovation. So our innovation, of course, from the industry has to be challenging that onslaught. But thanks a lot, Sanjay and Shyam, for a very illuminating discussion. We are sort of now at the end of this day-long conclave. Just to remind everyone, today was the first day-long conclave that we'd organized in a long time, Press Freedom at 75. I'd like to thank everyone involved in organizing this, all the speakers of this session and all the speakers since morning, everybody who helped us organize this conclave, led by the programs committee, led by Kumkum Chadda. And Seema, Vijay, can you get Seema to sort of, come to the speaker
Sure.
window? Yeah. And it's really been a very, very, interesting and a fruitful day for us, at least. And again, I'll remind that for Shyam and Sanjay, media laws was something that was pervasive through the discussion. I think whether it was ethics, business, or trolling, a bulk of discussion was on how laws are being used or how provisions are being used against media. So that is probably at the heart of most problems that we are facing in. Not to take away the attention from the problems within media, of course, of our own ethics and our responsibility. Seema?
Yeah, well, you said it all, and this was very, very interesting. And I think you've given us many suggestions, both our lawyer friends, which we can look at now very seriously in the Editors Guild. The day has been a very long day for many of the attendees, and for all of you who've given us so much time. I'm not going to take your time further, and especially lawyers' time costs a lot. So thank you so much. And thank you for being there with us all through this. Thanks.
Thank you very much. Thank you. Goodbye.
Bye. Thanks, Anant.
Bye. Thank you.